This program was brought to you by the Illinois State Bar Association. All copyrights are owned by the ISBA. If you have any questions regarding the content of this presentation, please contact the presenters at isba.fastcle.com/questions.
All right, we can go ahead and get started. I first want to thank everyone for coming today. This is the third luncheon in a four-part series that the Young Lawyers Division from the ISBA is putting on. It's entitled Graduating to the Bench, and as you can see, we have a great panel of speakers today. My name is Heather Pfeffer. I'm on the committee for the PDL luncheons, and I'm going to be moderating the discussion today. I do plan to stop at different points if you have any questions, but if at some point you do have something you want to ask or point out, just flag me down. Jessica over here is going to be helping out. We're taping this so we can put it online later, so it'd be helpful if you just had the microphone before you asked your question. I'd like to begin then by introducing our panelists, and I'm going to start over here with the Honorable Judge Nancy Katz. She's an associate judge of the Circuit Court of Cook County. She was appointed to the bench in November 1999. Since April 2000, Judge Katz has been assigned to the Domestic Relations Division, where she presides over an individual calendar. Judge Katz is a 1983 graduate of Chicago-Kent College of Law. From 1995 to 1999, she served as the Assistant General Counsel for the Illinois Department of Children and Family Services, where she supervised the legal work of the department in the Cook County Child Protection and Juvenile Justice Divisions of the Circuit Court of Cook County. Prior to that, Judge Katz worked for over 10 years as a staff attorney, supervising attorney, and project director for the Legal Assistance Foundation of Chicago. She also served for 1.5 years as the Assistant Ethics Counsel for the ABA Center for Professional Responsibility. Judge Katz is a member of the Committee on Education of the Illinois Judicial Conference, and she frequently speaks on family law issues to legal, professional, and lay audiences. Sitting to her right, we have the Honorable Judge Tom Hogan. Judge Hogan was appointed to the bench in 1997 by the Illinois Supreme Court and was first elected to the same position in 1998. He's been retained in both 2004 and 2010. Judge Hogan has presided over 300 jury trials in the 1st Municipal District and the Law Division in his time on the bench. He's run for the 1st District Appellate Court in the Democratic primaries in 2008 and 2010. He teaches trial advocacy to law students and lawyers and judicial conduct to new judges. In addition to these accomplishments, Judge Hogan is quite active in the legal community given the numerous roles he serves with the Chicago Bar Association. And then seated to my right, we have Justice Holdridge. In 1994, Justice Holdridge was elected to the Illinois Appellate Court, 3rd District. He served several terms as the presiding judge of the court. Justice Holdridge also is one of 5 judges who hears the statewide appeals of the Illinois Workers' Compensation and Occupational Disease Act cases in Chicago and Springfield, serving as the presiding justice of that court. In addition to his court duties, Justice Holdridge has served as director of the Administrative Office of the Illinois Court System, overseeing all of our courts in the state, and as a trustee of the Illinois Judicial Retirement System of Illinois. Prior to his election to the appellate court, Justice Holdridge was elected a full circuit judge in the 6 counties of the 9th Judicial Circuit, presiding over both criminal and civil trials. Before being elected to the bench, he practiced law in Peoria and Central Illinois, and while in practice served as an appellate law clerk justice to Justice Albert Scott and as a Supreme Court clerk to Justice James Heipel. In 1998, he was chosen Alumnus of the Year of Southern Illinois University School of Law. In 2010, he was awarded SIU's Distinguished Alumni Achievement Award. Justice Holdridge's chambers are in downtown Peoria, and his appellate courtroom is in the historic former Supreme and now appellate courthouse in Ottawa, Illinois. And last but certainly not least, we have Mr. Al Durkin. Al Durkin has over 30 years of experience as a personal injury litigator. While seasoned in all types of personal injury litigation, he's distinguished himself in the areas of complex traumatic brain injury and psychological injuries resulting from exposure to trauma, including post-traumatic stress disorder. An active member of Illinois' legal community, Mr. Durkin holds several positions within the ISBA. He's currently serving his 4th elected term as Cook County representative to the Illinois State Bar Association's General Assembly. In addition to elected office, his ISBA service includes acting as co-chair of ISBA's Judicial Evaluation Committee and as secretary of the Tort Section Council. He's also currently running for the ISBA's Board of Governors. Mr. Durkin is a frequent author for ISBA publications and frequent speaker at ISBA programs. He received his law degree from DePaul University and his bachelor's from Lewis University. And again, I want to thank all of our speakers for being with us today. And also, before I forget, we would just ask that once you leave, if you could just take a short moment of your time to fill out an evaluation so that we can see how we're all doing and so that we can keep these lunches going in the future. So let's kick off our discussion. I guess I'd like to start off maybe by directing this to our judges on the panel. This seminar is titled Graduating to the Bench, and as young lawyers who may be thinking about that possibility down the road, was there a certain part in your, or portion in your career where you actually started thinking of a career in the judiciary? And anyone can start. I'm not going to...
I'll start. I'm Judge Nancy Katz. It never occurred to me that I wanted to be a judge until fairly late in my career, and I started my career as an advocate, public interest lawyer at the Legal Assistance Foundation of Chicago, and I saw myself as a legal aid lawyer, a public interest advocate. And so my first exposure to the judiciary in a way that made me think I want to belong was at the juvenile court when I was working for DCFS, and it was just a wonderful place, and there were just so many dynamic judges there, and I could see what good they were doing for children in our state. And not only were they presiding over individual cases, but the court itself was on the forefront of making changes for children in the state. And Nancy Salyers was the presiding judge at the time, and I thought to myself, she is a wonderful role model of what a judge can do in this state, and I want to be like her. And so that was the first time, was in 1995, that it occurred to me that this would be something that I would want to do. So my path is a little bit unusual than many judges who come out of state's attorney or public defenders or high litigation in civil areas. I came out of a kind of a different angle.
I did not contemplate trying to get on the bench until many years into my practice. I practiced in both the state and federal courts of Illinois, Wisconsin, Indiana for a number of years, almost 18 years before I went on the bench. So I think what I experienced was the thought that as I sat through rather long court calls day after day, that I could do as well or better than the people who were sitting up there. And I'm sure many of you have thought the same thing as you have been sitting in those kind of court calls. But it didn't become really a plan until the late 80s or early 90s. And so I was, by that time, I started practicing in 1980, so I'd been practicing for 10 or 15 years before I started to contemplate the possibility.
Well, I'm surprised I'm here, and actually surprised by my career, because I was practicing. I actually was teaching as well down in Southern Illinois University, and came up to Peoria and opened practice and was practicing, and just by happenstance, serendipity, I happened to meet Justice Albert Scott on the 3rd District, and actually we were at a social function, and he had lost a clerk, and at that time Supreme Court rules do not prohibit you from working with an appellate or even Supreme Court justice and still maintaining your practice. Of course, if you had a conflict, you would go to, as I did, down to the 4th District instead of the 3rd District on any cases that were taken up on appeal. And so I was just asked to help out. And so that kind of just snowballed into exposure to the judiciary and reviewing trial judges' decisions at the Intermediate Appellate Court, and then through that process I met Justice Heupel, and he had lost the clerk as well, and so I was doing kind of pinch hitting, filling in, and so I was exposed to the judiciary. I actually always thought that I would just go back to the full-time practice of law, and then as you know, we elect judges downstate, particularly in open primaries and contested partisan primaries, and it was suggested to me by Justice Scott that I run for his seat, and I thought, well, that would be kind of an interesting experience, and so that's the way I started. First exposure by clerking, and then following into the process. So that's what led me to where I am today, and it's just been kind of, you never know what's around the corner type of experience.
Did any of you find that there was anything in your previous legal career that made you more prepared for that transition into becoming a judge?
In my experience, I was engaged in general practice of law, which you can do downstate, I think, a lot easier than you can up here. So I handled anything, and when you're a solo or a small practitioner, you look for referrals, you give referrals, you're part of a bar, like in the Peoria County Bar, it's I think about the second largest bar, or at least the third largest bar association, county bar association in the state. And so I had a general practice, and I think that general practice exposing me to criminal matters as well as civil matters was most helpful for especially the type of judicial practice that we do at the trial court downstate.
I don't think that, from my perspective, there's really not much that can prepare you for the immediate transition. The move from being an advocate to being a judge is rather, it's a big move. And as a judge, I moved from a very active trial practice in the state and federal courts. I represented railroads throughout Indiana, Wisconsin, and Illinois. And so I was in a lot of different courtrooms, but when I became a judge, I went right to traffic court, and I was making more decisions in 15 minutes than I was for a week as a lawyer. So there's not much that can really prepare you for the immediate transition. I guess my prejudice is that if you are thinking about becoming a judge, make sure that you have, I'd say, at least a moderate amount of courtroom experience, because there's so much that goes on in a courtroom that you need to know as a trial judge that if you don't have it, it's going to make the transition even longer than it might otherwise be. And so that's kind of my advice.
I agree with Judge Hogan. I think having a broad range of trial-related experiences prior to getting on the bench is really helpful. Particularly high-volume courtroom experience is very helpful, particularly for the first part of your career as a judge, where you end up in usually high-volume courtrooms. If you're in Cook County, and in the other parts of the state, you're seeing a broad range of types of cases. So the more exposure you can get to a wide variety of practice areas and trial experience, I think is helpful for the transition. And then there is just another factor which is kind of innate, and that's your personality type and your ability to handle the stress of being on the judiciary, the isolation of it, because if you're working in a firm, you're talking to your partners all the time about cases, and you're in a team and you're brainstorming. As a judge, you're far more isolated, you're making decisions on your own, so there is a personality issue there. And then your temperament. Can you go from being an advocate to being a more impartial arbiter of the law? And that is another one of those things you have to gauge your own sense of self and identity, and will that role suit you? You know, I think I'm a better judge than I was a lawyer, because I think that this role suits me better. I was a great advocate for the cases I believed in, not so much on cases I felt indifferent to, and honestly. So for me, the role is a very good one, and it's a really good fit.
I guess I want to switch gears a little bit then, and your bios all kind of talked about the different paths that each of you took to the judiciary, and I think Justice Holdridge mentioned running. Maybe we can now talk about the practical steps that are involved after a young attorney or any attorney might make the decision to become a judge. Anyone wants to take this, either how did you get there? Was it by appointment? Was it by election? And if so, what are those steps that must be taken to accomplish that goal?
Let me start. I'm an associate judge. There's two types of judges in the state of Illinois, and this is by virtue of our constitutional provisions and our Supreme Court rules. There are associate judges and there are circuit court judges at the trial level. Circuit court judges are elected and have to stand for retention every 6 years. Associate judges are appointed by the circuit court judges in their area. So in Cook, the circuit court judges of Cook County appoint the associates, and there's rules that govern that. But I call the associate route merit light, because there is a baseline of being qualified and merit, and after that there are certain politics to the appointment process. So the associate route is an appointed process, and that's what I did. And in various areas it looks different. I think the most important thing is that you have trial experience. I think that helps enormously at the associate level, and that you're active and known in the legal circles, because the other circuit court judges are going to be voting on a number of candidates. They usually, if there's 2 openings, there's 4 candidates, so they're going to vote on those they find best qualified for the job. So being having good trial experience and being involved in the bar and in a variety of community organizations and legal organizations, I think is very helpful to be known and to be respected in the legal community. So that's the associate path.
I am a full circuit judge, so Nancy's described the difference. I would say that there's politics involved in just about every business that we have in our country, and I suppose you could use politics with the small p, and by that I mean you just have to be able to get along with people. So but having said that, becoming a judge is a very political process, whether you're doing it as an associate or as a full circuit. The politics that Nancy described to some extent with the associate judge I won't go into, but the politics that are involved, in my view, in running for either full circuit or sub-circuit are much different today than they were when I first ran in 1998. I know most of you probably believe that the Democratic machine here in Cook County decides who's going to be a judge. Certainly our media does. I mean, and we hear all the time, most recently in the cases where certain the judges asked to be relieved of responsibility to hear cases because they had some, tangential connection with some of the parties in the case. So I think the perception is, and I don't believe that it's true, but the perception is that everything is political, and everything isn't political once you become a judge, but there's a lot of politics involved before you become a judge. So if you're thinking about running, the first decision you have to make is, are you going to run countywide, or are you going to try to run in a sub-circuit? There are politics involved in each of those. You have to get political sponsorship in each of those. So, but I don't think political sponsorship is as important countywide as it was when I first ran, but it does help. The second thing you have to do is you have to be prepared to raise, in either race, well over $100,000. It's especially costly to run for judge. You have to get a social media person. You have to pay that person, I'm assuming, unless you have a relative or a friend who is very adept at this, who will spend hours each day deciding or doing this for you for free after, of course, you've talked with them. You have to, you probably have to start talking with others in the community in which you're seeking to run. I'd say at least 15 months out from the election, because there are those, I can tell you, if you're intending to run in 2014, there are others who have already gone and started their campaigns. So you have to have money, you have to have stamina, and you have to have have a plan. And those are the things you have to start with. And once you have all those, or at least you're starting to move towards those, you have to figure out how to get on the ballot, and that just requires, I think it's around 3,500 signatures countywide. Maybe it's a little higher now. And in the sub-circuit, I think it's under 1,000. But you got to get signatures, and then you have to be prepared for ballot challenges, because people will challenge your ballots or your signatures. So that means that the safe course is that if you need 1,000, try to get 4,000. If you need 3,600, try to get 10,000. That in and of itself can be an expensive proposition, again, unless you have people who are willing to help you go out and get those or signatures, and they have to do it pursuant to the rules provided in the election code. And then you just have to prepare, as you get closer to the election, the primary election, you have to prepare for 3 to 5 nights or days a week going to events. If you're in a sub-circuit, every block club that has a coffee, you should try to appear. If you're running countywide, then it's much more difficult. There are ways to do it. It's helpful if you're, that's where the political sponsorship helps, because that person or a group of people can provide you with ideas about where you should go and who you should talk to. My final thing is to say that you should talk to as many people as possible when you're doing this, whether it's in the sub-circuit or in countywide, because even if you know someone's not going to support you, you should go talk to that person, because you'll learn something. And the process of running for office, and I've done it 3 times for a new position and twice for retention, and the retention election really isn't that, you can't compare the two. You learn a lot on the campaign trail, and you really learn, I learned that the people who run for election, I'm not talking about what they do once they get there, but people who run for election, if they do it in an honorable way, are really working hard. And that's the kind of campaign that I wanted to run, and if I would encourage you to run that kind of campaign if you were to run.
Justice Holdridge, do you want to explain a little bit how your career took you from being a lawyer all the way up to the appellate court?
Well, I think Judge Hogan and Judge Katz both explained very well what my understanding of how you arrive on the bench in Cook County. And it's a similar process in the larger collar counties as well. Will, DuPage, they're very similar. The more that you move downstate or into the western part of the state, the less some of those things matter, so to speak. I mean, it is not unheard of for an experienced, well-thought-of lawyer in the community to decide one day, I think there's an opening for a circuit judge. And, you know, I'm going to go and get my petitions. I'm going to go to the State Board of Elections and get all the materials and the rules and the regulations, and I'm going to fill them out. I'm going to contact my friends, and we're going to circulate those petitions, and you're off and running, and you're running a campaign. You may have an opponent in a partisan primary. You may not. You'll certainly, most counties, you'll have a contested election in the general. And so from that, it's a freer process, I think, and a little more, much more open process downstate than having served with many of the Cook County judges over the years, than the process they had to go through. And so I just hear stories about these different types of activities. But you do the same activities. You make your own schedule. You have your own campaign manager. You may be, and I have been in the past, my own campaign manager. And you go out and you go and meet the public. But your biggest advocates are members of the bar, fellow members of the bar, fellow attorneys that you practice with, because the general public looks to attorneys to say, hey, what about this Holdridge fellow? What about this Hogan fellow? What about this Katz lady? What do you know, I hear they're running for judge. What do you know about them? That word of mouth endorsement is just so invaluable for many, many people. And so that's very important. So it goes back to the relationship you have with members of the bar and how you practice law, the respect they have for you. That will in turn, that respect will translate into support for you to become a judge. And just as important, to become an associate judge. Because the more you appear before the circuit judges, they are the electorate. Okay? They are the electorate if you're looking for an associate judgeship. The more you're in the different courtrooms appearing before those judges, whether it's a circuit judge or an associate judge, whoever's on the bench, the impression they have of you as to how you handle your case, how you handle your client, how you interact with fellow judges or fellow attorneys, not just with the bench, but with fellow attorneys, is going to form an impression. Downstate, we have many, many attorneys who apply for associate judgeships. The most common criticism I hear, who are these people? We've never seen them in our courtroom. We don't have a lot of knowledge about their experience because they haven't practiced. So from an associate judgeship standpoint, at least, and I assume maybe in the collar counties it's just as true, the more you appear to these circuit judges and also the associate judges on the bench, the impression will translate into, well, look at who's applied for an associate judge. That person has done a good job in my courtroom. Okay, so that endorsement is very valuable. But you can come out of left field downstate. You can just graduate. You can come out of left field and you can have fun if you like to meet people and go around and shake hands, etc. So you can become a judge that way through that elective process. As I've studied the Cook County experience and the sub-circuit experience, and as I say, as I've become familiar through stories about that process, it's clear, just clear as whether or not a political organization can help you get elected. The point is, you've got to at least be able to be on the team to pick up the bat to have a pitch thrown. Okay? You got to get out of the stands and you've got to get on the field. And how you get on the field is, quite frankly, I was thinking sometimes, if I was up here, what would I do? Well, you've got to start knowing who are the political players in your communities, and you've got to make a decision as to whether you can relate to that process. Okay? And if you can't relate to that process, I would say up here it's going to be difficult to get on the bench. Okay? Now, I can argue that the process is good, and there are people who will argue the process is bad. But I think to a certain extent, being part of the process and being involved in the process, there's a set of skills there, people skills, that I think would serve you very, very well when you're on the bench. And so from that standpoint, I hate to criticize each areas how they go about selecting judges, but that's maybe doesn't even address the question. But
That's good.
the best I can do.
Thank you. Does anyone have any questions at this point before we move on? Yes, let me get you a mic so that we can hear you.
This would be for Judge Hogan. Perhaps you could just clarify some things, because we heard associate and then circuit, and then it seemed you branched it off into sub-circuit versus regular circuit. If you could maybe Just explain the difference, perhaps what you yourself are, and maybe why one person would go down one path or the other.
An associate judge is elected by the full circuits. If you run for office as a judge, whether it's countywide or in a sub-circuit, you are classified as a full circuit judge. There are, I think, around 250 full circuit judges in Cook County and another 150, 170 associate judges in Cook County. So if you want to run and seek election from the general public, you would run for a full circuit position, whether it's countywide or in a sub-circuit, which is just a geographical location within the county. And Cook County, I think, is still the largest unitary court system in the world. To run countywide, you know, you're trying to do the same thing as a judge that the county board president does. So you have to go out and get to as many communities as possible, and it runs essentially from the Wisconsin border all the way down to, well, not all the way to Kankakee, but it seems like it some nights. It's a long hike, and the associate judge election is started with I think it's the same in all of the counties. It starts with an application to the chief judge of that county or that district, and then each chief judge has his or her own, I don't know what they call them, committees who review the resumes and then conduct hearings. In Cook County, I think all of the new, every time there's an associate judge election, the committee meets and it's reconstituted, and it meets with all the new members who have not been previously interviewed. And that's a very long process.
Why do some people pick a sub-circuit to run in versus countywide? First, you have to live in the sub-circuit that you are running in, so you have to be a resident. And some people find, I think, that the sub-circuit is a more geographically contained area, and that there's a little more independence at that level. Because you need less raw numbers to win, I think a lot more people who are relatively independent of the political machines will run as a sub-circuit judge. So I think that's one reason that people pick the sub-circuit. It's more doable. You also just run where there's an opening where you think you can win. And I want to say something about the whole political apparatus. There are plenty of people that have become judges who really have very little connection to the political apparatus. I think it helps. I think the Democratic Party is not nearly as invincible force in electoral politics at the judge level as they used to be. So I think if you talk to someone like Judge Hogan, who's been on the bench since 1997, versus someone who came in last year, you'd have a very different impression of how much assistance or barrier the Democratic Party, particularly in Cook County, the Democratic Party, is to running successfully for judgeship.
Thank you. Any other questions before we move on? All right. Now, Mr. Durkin.
Oh, I'm still here. I grew up, I want to be a judge.
Perfect.
Well, why somebody would pay $100,000 for $150,000 all year job? I'd like Mr. Hogan, Judge Hogan, to explain for me.
We heard in your bio that you are the co-chair of the ISBA's Judicial Evaluation Committee. Could you give us an idea of what the JEC is and what you do there?
Well, let me just backtrack a little bit, and then I'll answer that
Perfect.
question on a couple of things that were said here. You talked about the associates. They are appointed. We saw, I think, over 200 associate candidates last year on the JEC. There's also, in addition to the circuit judges that run, we saw everybody that ran for circuit judges. had retention judges, I believe, last year. We saw everybody that was a judge that was up for retention. You get a, was it a 6-year term, Tom? Yeah. We had to see them. But in addition to all those people, every once in a while the Supreme Court decides to appoint someone to a position. That's what we call an AOIC appointment, the Administrative Office of the Illinois Courts. Supreme Court has the authority to appoint open vacancies, appoint people. So somebody that may not have gone through an associate process, never saw the circuit court before, could theoretically be appointed to a seat and then need to run for that seat when it came up for election. So those are the type of judicial candidates that we do see. And the reason people want to be judges is obvious, because let's face it, being a judge, in my mind, is probably the highest position that you can hold in our profession. And it's a position of trust, that people trust in you. And we can talk about politics and everything, and there is politics involved. Don't let anybody kid you. But the judicial evaluation process that we do have here in Cook County, I believe, is the only form of what we might refer to as merit selection that there is. And here's how it works. I chair or co-chair a committee that has maybe 50 or 75 ISBA members on it. Everybody wants to be a member of this committee, and whoever's a member is appointed by our current president. So if you have any interest in being on this committee, and I did speak at one of your meetings a couple of weeks ago and encourage you to get involved, because from what I'm hearing here from the judges, they said one way you're going to get your name out there is to get involved in a bar association. And a good way to learn more about the judiciary and how it works is to get involved in a judicial evaluation committee. And I'll tell you why. I've been on this committee maybe 12 years. They're supposed to only be on 3 years and you go off. For some reason, they never take me off the committee. And they brought me up to chair now for the last 3 years. And the reason that it's so important is that I've seen people like yourselves who get appointed to a committee, and they're on 2 or 3 years, and then they go off, and the next thing I know, they're sitting on the other side of the desk. They're a candidate. And everybody in the room, well, I know John, I know Tom Hogan, he's a great guy, he was on the committee and he was very active, and that's how your name gets spread out there. So I'd say one way to get involved, other than having an uncle by the name of Madigan, might be to get involved in the Judicial Evaluation Committee. But here's how our committee works. You take those 50 or 75 people, and we have training sessions. The judges or people that want to be judges or associates have to come in and pick up a packet from Joyce Williams here. She's the straw that stirs the drink here in Cook County. She's an employee of the ISBA. They have a questionnaire that if you look at, it's like a phone book. And I always, sometimes I look and says, God, to be a judge, who wants to fill out that and go back and say, I tried a case in 1988, and Judge, Leonard Hand was the judge, and here's who my opposing counsel was, and all that. But you got to put all this information. But that helps prepare you, like you prepare for trial. Those are you are involved in litigation. You go back to the first day you took that file, and you're looking through it, and you're getting ready for trial. It helps prepare you about your career and how you're going to handle yourself. You fill out that application. Ms. Williams then assigns it to 2 investigators that she appoints randomly. We have, in our judicial evaluation in Cook County, actually, I'm the ISBA. There's an Alliance of Bar Associations. There's 11 different bar associations: Cook County Bar, Asian Bar, Lesbian and Gay Bar Association, Hispanic Bar. There's 11 different bar associations. None of them as big as the ISBA. We're the big brother of the Alliance, and I'm one of the executive directors of the Alliance too. So we might have 30 people in the room, and we hope there's at least 10 from the ISBA each night. But that investigator takes that application, and then their job, after they've been trained through one of our half-hour training sessions, and I encourage you again to join the JEC, and we'll get you trained to be an investigator. You go out and you call what we call references on the list. People that may have tried cases with, or their law office partners, or that kind of stuff. And we also then, our investigative training trains our investigators not just to call Judge Hogan's brother-in-law that he lists prominently in his application, but maybe his next-door neighbor.
I didn't think you'd catch that, Al.
His next-door neighbor who, his dog pees on his front lawn or whatever. We call him too. You go off list. and try to find other people too. And the whole idea behind the investigation is to make it accurate, fair, and complete, so that they get all that information. And then what happens is those investigators do a report. It might be 2-3 pages. And in that report, we have criteria that they're supposed to look at whenever they're interviewing. Maybe some of you have been called already on these type of things. We go into what is the litigation experience of the applicant? What kind of work do they do? What is their professional experience? Are they involved in law-related things in the bar associations? Are they a member of the JEC? Were they in the Young Lawyers Division? Do they write for the bar associations? Do they speak at bar associations? So, I mean, to be a well-rounded person, to be a judge, you need to do more than just study the law books. You need to be out and about and do things. So you look at their litigation experience, their professional experience, their health and age, although Judge Maddox kind of did away with that when they took away, they used to have a mandatory retirement, I think, is 75, and there is no mandatory retirement anymore. Their legal knowledge. How are you going to find out about their legal knowledge? Well, if they've written or they've been to the appellate court, they might have had some decisions. You go get their decisions or a summary judgment they wrote or whatever, and you see if, and then you're asking, you know, their opponents and stuff, what kind of a person was it? What was their character like? What was their integrity? And they'll say, well, that person, you know, everything, give me answers, interrogatories, but he hides stuff or whatever, you know, that kind of stuff. So I mean, it's an open book. And then what happens is we put all that together and get the report, and then the candidate comes in for an interview. Now, to be an interview, you need to be chair qualified. Somebody like myself or somebody that's gone through our program conducts the interview and starts asking questions based upon that report. And so at the end of the day, as we say, all the various bar associations that participate in that process will vote whether they felt that the candidate, based upon the materials, the questionnaire, the investigation, and the interview process, was qualified, highly qualified, or not qualified. And that would be for an associate position or a circuit position. If it was retention, it's only recommended for retention or not recommended for retention. And we do that for the appellate court, too. So, you know, I don't want Judge Holdridge to feel left out. We have justices that come through and they're up for retention or they're running for an appellate court. Now, we may find somebody qualified for circuit court that'd be a great, you know, judge or whatever in a circuit court, but 2 years out of law school, they say, I don't want to be a circuit court judge, I want to be an appellate court justice or on the Supreme Court. So we have different criteria for those different positions, all the way up to the Supreme Court. This past year, we had, you know, Justice Tice came before us, and Justice Paczynski and Judge Riley. They all ran for the Supreme Court position. A couple of years ago, Tom Kilbride, the chief judge, was up for retention. He talked about $100,000 to become a circuit judge. I think that race just for retention was in the millions of dollars. So it is costly, and it is political, and it is there's lobbyists involved and all that stuff. But we are the merit group. So, but what happens is Judge Evans, you know, wants our opinions on this stuff, and we give them the information and what they do with it. Then they go, the judges do their thing like they do in the Vatican. They go out and the white smoke comes up or the black smoke comes up, whether they're found qualified or whatever. But that's what we do. It's a lot of work, but it can also be very rewarding, and it does tell you a lot about the judiciary. So that's pretty much the
How long does the whole process start, from the time you start gathering information to the time you sit the candidate down and interview them?
Well, that depends. Like if it was for the circuit court elections, there are certain time periods because we know when the election is, so we have to have all of our stuff in a good maybe 45 days before the election, because this past year we started giving reasons for our decisions, and we try to get the information out there. And obviously it's a very frustrating process because a lot of times even retention, I can't remember the last time that somebody was not recommended for retention and was found not recommended. They end up eking out their 61%. They need a 60% tally to stay on, but they stay on, and it gets frustrating, and then our members quit, and we need new people, new blood like you, because if you why are we spending hundreds of hours a year volunteering for this? By the way, as an aside, I am trying to get CLE credit for people that participate in the JEC. I think you should at least get that hour or 2 hours you need for ethics, if you're sitting there in judgment on people that want to be judges, why don't we get credit for it? So I asked you to write your congressman or state representative, or whoever is in charge of that stuff. But did I answer your question?
Yes,
Takes
perfect.
45 days or whatever, probably beforehand. Unless now the AOIC, they could come today and say, Joyce Williams, we want to appoint Jessica Durkin to judge, and we want your report by January 21st. That happens to us all the time. And then so we got to put everything in high gear and get an investigator right away, get the report, get the candidate in, and that kind of thing. And then sometimes they don't ask us for our opinion. They just make somebody into justice on the appellate court, and we have no say-so.
Can I just add to what Al had to say? That is what the committee is doing, but there's also, to talk about interacting with your fellow members of the bar, how important it is. There's also the judicial advisory poll that the state bar sends out to whatever jurisdiction you're running in, asking opinions on a questionnaire as to your suitability to be considered for a judgeship. And if you're not even a member of the state bar, if you write to them, as long as you're admitted to the Illinois bar, they will provide that questionnaire to you as well. So the Bar Association is very active in soliciting the opinions of the practicing bar as to your candidacy.
Thank you. Any questions before we move on to, I think, will probably be the final portion of our discussion? All right. Well, as you know, we have some judges from different divisions. We've got someone from the domestic relations, Judge Hogan from the law division, obviously Justice Holdridge from the appellate court. I'd like maybe each of you, if you could just give us a brief idea. Obviously, you know, we understand that you probably hear arguments, or Judge Hogan presides over trials. Is there something about your job as a judge that young lawyers or any attorney might not know simply because we've never done it?
Well, I sit in the domestic relations division of the Circuit Court of Cook County, and so I hear, and I have what they call an individual calendar, so I hear cases from beginning to end, and never end is what I say for post-decree cases. So I hear everything from the preliminary motions to discovery disputes to evidentiary hearings. We have petitions for declaratory relief. We have summary judgment motions. The area of domestic relations is pretty broad because we do everything from deal with complicated custody and mental health issues to valuing multi-million-dollar businesses for the purpose of a dissolution. So it's quite a broad area, which is what I like. And it's both got that human element, which you have to have the right temperament for. Some people don't like it because there is a high emotional content, and other people love it because it's meaningful and involves things that people care very deeply about. But I want to say one thing to all of you. If you're thinking about a career in the judiciary, and it kind of gets back to what Mr. Durkin was talking about, when you fill out that application to be evaluated as a judge, you have to go back, and they ask lots of questions. So you have to keep track of your important trials and important writing and important opinions. But one of the things they ask is for you to take your 10 most recent substantive cases and provide the names of both, you know, counsels for each side of the case. And so when I was running for the first time, I had to put down the names of all the opposing counsels on the last, 10 or 20 trials or substantive hearings I did. And so when you think about the importance of an ethical and cooperative practice of law, don't forget that they're going to go to the people that you work with, your colleagues, and your opponents. So what I like to tell young lawyers is, today they're your opponent, tomorrow they may be your partner, and the next day they may be your judge. So it really behooves you to practice with professionalism and cooperativeness, and to practice with a high degree of professionalism, because you don't know today where you're going to be in 5 years or 10 years in the legal profession, and your reputation is all you have as a professional. That's what you're selling. You're selling your knowledge, your experience, and your reputation. And it's easy, it's hard to gain a good one, and it's easy to lose one. And so just keep that in mind as you practice, no matter what kind of practice you have.
I think it's important for you to kind of think about, if you are thinking about becoming a judge, that where we are now is much different than where we were when we first became a judge. Most judges in Cook County, at least, start in traffic court. I don't know whether you did, and traffic court is, in my view, one of the great experiences that I've ever had. First of all, it provided me with a lot of entertainment, but it also, it's the one spot as a judge where you really have a tremendous impact on the lives of others. You wouldn't think that necessarily, but you have people who are, and now we don't have this because we have all the speeding cameras and the red light cameras, but when I was in traffic court, we were doing speeding cases and red light cases, and this is the only time most people have any kind of contact with the judicial system. And if they're treated poorly, it's going to reflect poorly on all judges. So it's a great opportunity to learn how to be a good, decent judge, because you have to treat everyone with courtesy and respect. And that's what litigants deserve, whether they're at traffic court or in the First Municipal District or in domestic relations or in law division or the appellate court or the Supreme Court. Our system really depends upon that concept. The extent to which we leave that behind and just become robo-litigators who just want to burn all the earth in front of us, we're going to do a lot more, or continue to do a lot more damage to our system, and you have to keep that in mind when you're practicing and if you do become a judge.
Your question again, Heather, was?
It's kind of the wrap-up topic. So my question was, is it, what in your daily life as you're an appellate judge now, what kind of duties or responsibilities do you have that we might not think about, administrative or anything else? And then again, if you have any words of wisdom for any of the young lawyers here.
Well, when I was a circuit court judge, your duty was to make the decision affecting the parties, come up with the right decision, apply the law to the facts and circumstances, and hopefully not have it reversed on appeal. Okay. Now, that's what you do as a circuit judge, and it's so very, very important. On the appellate court level, when you review a case and you write a decision, even if it's an order, but of course if it's an opinion, especially so, what you write will be examined by the bar, will be examined by the bench, by the trial bench, okay? It's where the rubber meets the road, is the trial bench. And they will be looking for guidance and direction on future cases similar to those facts and circumstances of underlying the decision we're making in a court of review. So I think we are always constantly asking ourselves, or we should be at least asking ourselves, if I write this sentence this way, how can it be interpreted, and does it really encapsulate what I really mean here, or what our panel really means should be the law as we apply it to the facts and circumstances under review. That's something that I don't think people notice, that pressure that we're on in courts of review, or that we should be, because we're really writing the law on review besides reviewing that case that's just brought before us. So I think that's something that people don't often understand. Administratively, we take all cases. We do not get to select. The Supreme Court gets to select. So we take all criminal, civil, and administrative review cases. I guess to wrap up, just some words of advice. And I think we've all been kind of talking about this, but if you are serious about looking for a career in the judiciary, pick a judicial mentor. Okay, you've been in the courtroom. You've been, and this is where you can find judicial mentors. Is be active in the bar associations. Okay, be they ethnic bar associations, be they interest group bar associations, or whether they be the state bar association. Pick a judicial mentor. Pick a judicial mentor that's an associate judge, a judicial mentor that's a circuit judge. Okay, If you can't find a mentor, you might want to think that maybe it isn't a good field for you. Okay, I mean, you know, you want to have a personality where someone really wants to mentor you. Okay, and ask how they got there, and let them take you under their wing. Okay, not only can they become good sponsors for you, but they can kind of direct you as to what you should be doing. So that's what I would suggest you do. Also be active in your bar associations, which I just mentioned. And also be active in your community, okay, in your church and communities, okay? Ask yourself, what community associations or organizations do I belong to? Okay? Am I a Rotarian? Am I a Lion? Or if not those types of associations, what groups in the community have I been involved in? Not only does this help you develop a base for being supported to get onto the bench, but it certainly will help you in practice. It's good client development, okay, as well. And also, be active in politics, okay? It's political. I think Judge Hogan, Judge Katz acknowledge that. Mr. Durkin has as well. There's nothing wrong with politics. I think, come on, we're Americans. Politics, okay? Get involved. It's something that you need to get involved because you're the type of people that need to be involved in politics, okay? Think of how you got your license. Think of the character and fitness examination that you had to go through to get your law license, okay? There are a lot of people involved in politics that never went through a character and fitness examination. And so you need to replace those people who couldn't pass a character and fitness examination. And so you need to get involved so it's done correctly. So I think that's what you need to consider doing. And you need to, just as a practical thing, take out that questionnaire that the State Bar Association has. Look at it. Someone said years ago you should write your obituary every year and revise it and see what it looks like. And it'll tell you where you've been, and if it doesn't look like what you want other people to say, where you've been and what you've done, then start changing that. And I think if you take that questionnaire and look at it, it will tell you what are those important things from a legal standpoint and experiential standpoint you need to be striving for today so that when you have that form, because I filled it out for election, I filled it out for retention, you look at that and you say, gee, man, that way. You know, and there it is. That's your life you're writing down, your life in the law. And so it's the guiding point. Those things are also very important. And so that's the way you start building towards that ultimate achievement that you're looking for. Thank you.
Thank you. All right, I think we're right at our 1 hour mark, but I just want to make sure that no one has any questions that haven't been covered before we wrap up. All right, well, again, I want to thank you all to our panelists. This was a fantastic lunch, so thank you very much for coming.
Thank you.